All right, well, as you've heard, a major euthanasia battle is heading to the High Court in Wellington today as lawyer Lecretia Seales fights for her right to end her life on her own terms. The 42-year-old is dying from a brain tumour and wants the right to end her life with medical help. Here to discuss the legal ramifications of this case is Otago University law professor Andrew Geddis. Andrew, thanks so much for joining us. What, if anything, makes this case different to cases we've already been through?
Well, this is the first time someone has gone to the High Court and asked the High Court for a declaration as to how the law actually applies to someone in their case. So what Ms. Seales is saying is that under the Crimes Act, it can be interpreted in a way that allows a doctor to provide her with aid in dying without that doctor then facing criminal charges afterwards.
Now, this is a very hard thing for the court to judge on because the court, first of all, has to determine whether or not it is capable of making this judgment. Do you think that this is a judgment for the court or for politicians?
Well, ideally it would be for politicians. However, the court has to interpret the law that's written before it. And it is quite possible that I think there's a reasonable legal argument that you can interpret the law in a way that allows Ms. Seales to get the aid in dying she seeks. However, we have to recognise that would involve the court making something of a social policy judgment, and a court may be reluctant to do that.
Will they take into account, as you say, the court may be reluctant to do that, will they also take into account that twice before this has been before Parliament and has been rejected?
Yes, it has been before Parliament. However, it only got through to the first reading stage. We haven't had a select committee actually look at this at a stage where the public can get in and actually have their say. What I think those earlier appearances before Parliament really represented was Parliament saying, this is too hard, we don't want to deal with this is frightening, and just throwing it out. If Parliament had had a good go at it and a really strong debate over it, I think there'd be a stronger argument the court should keep out.
There has been some suggestion that if the court were to support Lecretia in her aims, that it would not set a precedent. But I find it hard to believe that that is the case. Surely it would set a precedent.
Well, it'll depend on the nature of the declaration the judge gives at the end. The judge may give a wide declaration that could apply to a number of individuals immediately, or it may be a narrower declaration, something along the lines of Ms. Seales in her situation, the law applies in this way. Even in that latter situation, however, anyone who's like Ms. Seales could then go back to court and ask for a similar declaration. However, that would be terrible. We don't want people at the end of their life having to constantly go to court to ask what their legal rights are.
Yeah, and many of them would not be anywhere near as capable of doing it as Lecretia Seales is. Strictly, Andrew, from a legal perspective, so only looking at this from a legal perspective, what chances are there that this case will be successful?
I'd say it's probably a 50-50.
Really?
I think she's got a very strong argument. Yeah, well, I think there's a very strong argument that she does have a right to receive this aid in dying. Overseas courts have found that in a number of cases. The question really is whether a court will feel comfortable interpreting the legislation in the way she asks. And, you know, that then comes down to the individual judge and what he sees his role as versus what he sees Parliament's role as. That's a very hard thing to predict.
Andrew, thank you so much for joining us. Fascinating. Andrew Geddis, Otago University law professor there.